To help with touching Spirit Bear and understanding the difference between our justice system, traditional justice system, and circle justice, which we're going to be getting into tomorrow, I think you need to have some background about our justice system. So here we go. Since the establishment of the first juvenile court in Cook County, Illinois in 1899, states have recognized that children who commit crimes are different from adults. As a class, they are less blameworthy and they have a greater capacity for change. By the mid-1920s, every state in the country had established a separate system of criminal justice designed to acknowledge these differences, called the Juvenile Justice System. The Juvenile Justice System has grown and changed substantially since 1899. Originally, the court process was informal, often nothing more than a conversation between the youth and the judge, and the defendant lacked legal representation. Proceedings were conducted behind closed doors with little public or community awareness of how the juvenile court operated or what happened to the children who appeared before it. Rather than confine young people in jails with adults, the early juvenile courts created a probation system and separate rehabilitation and treatment facilities to provide minors with supervision, guidance, and education. The lack of formal process and constitutional due process in the juvenile justice system and potential for substantial deprivations of children's liberty through extensive periods of incarceration, even in juvenile facilities, came to light in the landmark 1967 U.S. Supreme Court decision in result Galt. In Galt, the U.S. Supreme Court determined that the Constitution requires that youth charged with delinquency in juvenile court have many of the same due process rights guaranteed to adults accused of crimes, including the right to an attorney, the right to confront witnesses, and the right to confront witnesses against them. Following Galt, the Supreme Court extended additional constitutional rights to youth, including the right to have the charges against them proven beyond a reasonable doubt and the right against double jeopardy. In 1971, the Supreme Court ruled that youth were not entitled to jury trials in juvenile court, but several states have judicially or legislatively elected to provide youth a right to a jury by trial. Lots of big words, lots of stuff to explain. Bottom line is, initially, it was a case of juveniles went and met with a judge, and the judge said, here's what you did, here's the consequence. Now what they're saying is, as of 1967, it was more of a trial, like what you're used to seeing. It's still just a judge, not necessarily a jury, but you have this child is now allowed to have a lawyer. They're allowed to have their case proven or correct or wrong or incorrect. That way, it's more of a fair system. Following the shift to ensure process in juvenile court proceedings, an increase in juvenile crime rates in the late 1980s and early 1990s prompted legislators to adopt tough-on-crime policies, depriving certain youth of juvenile justice system protections. States enacted mechanisms to move youth from juvenile to adult criminal court for trial and punishment. In some cases, these laws saddled children with the most severe sentences, death, and life without the possibility of parole. Many of the new state laws also exposed youth to the dangers and potential abuses attributed to incarceration with adult offenders, much like they had experienced before the creation of the original juvenile court more than a century earlier. So, in the late 80s and early 90s, crime went up, so they started to try children as adults. By doing that, they're saying they're not going to change. They were treated and put into adult prisons, which is kind of scary if you think about it. Since the 1990s, juvenile crime rates have steadily decreased, yet the harsh penalties of the 1990s remain in many state laws. With this shift, key distinctive and rehabilitative approaches of the juvenile justice system have been lost to the more severe consequences attendant to criminal justice system involvement. What they're saying is crime rates have gone back down, but yet they're still trying kids as adults. So what they're saying is by doing that, you're losing like the counseling and the way to make the kids better human beings and be productive citizens. Today's juvenile justice system still maintains rehabilitation as its primary goal and distinguishes itself from the criminal justice system in important ways. With few exceptions, in most states, delinquency is defined as the commission of a criminal act by a child who is under the age of 18 at the time. Most states that allow youth to remain under the supervision of the juvenile court until age 21. In lieu of prison, juvenile court judges draw from a range of legal options to meet both the safety needs of the public and the treatment needs of the youth. Although youth may be confined in juvenile correctional facilities that too often resemble adult prisons and jails, routinely imposing correctional practices such as solitary confinement, strip searches, and the use of chemical or mechanical strains. Here's something you'll like, the fact that youth are entitled to educational programming while incarcerated. Educational and therapeutic programming may be provided in the child's community, or the child may be placed out of the home in a residential treatment program in order to attend school on grounds. Unlike adult criminal proceedings, juvenile court hearings are often closed to members of the public, and records in some states remain confidential, protecting children from stigma and collateral consequences when their records are publicly available. However, juvenile records have increasingly become more accessible, and most jurisdictions are not automatically sealed or expunged when the young person becomes an adult. This creates barriers to obtaining employment, serving in the military, or enrolling in higher education programs. In other words, you commit a crime as a child. If that record is still there when you go to get a job, to join the military, or go to college, it can still be there, and it can keep you from getting into any of those type of programs. In recent years, research by the MacArthur Foundation Research Network on Adolescent Development and Juvenile Justice led many states and courts to view juvenile crime and juvenile justice through a scientific lens. Developmental psychology, which demonstrated youth's developmental immaturity, particular susceptibility to negative peer influences, and a capacity for change and rehabilitation, is supported by neuroscience, which has shown that key areas of the adolescent brain continue to develop until the mid-20s. This research has forced constitutional changes in how youth are sentenced when prosecuted in the criminal justice system, as well as required the adoption of new rules and standards for law enforcement, interrogation of youth, youth's competency to stand trial, and the reliability of youth confessions, among other things. Okay, this paragraph is saying, according to science, a youth's brain and development is very, very different than an adult. And because of that, they need to be treated differently. Last paragraph. Since 1975, Juvenile Law Center has worked to ensure that youth who are involved in the juvenile justice system have robust and meaningful rights, access to education, and developmentally appropriate treatment and opportunities to become healthy, productive adults. Juvenile Law Center works towards a world that affirms the unique and developmentally distinct qualities of youth, guarantees fair and equitable treatment, and ensures opportunities for successful adulthood.